Right, let's take you back to court now, the Protea Magistrates Court, where the 3 police officers who are charged in connection with Nathaniel Julies' killing are applying for bail.
All applicants to be granted bail. Your Worship, the defense for applicant number 3 is challenging the schedule. And Your Worship, I am sitting here asking myself as to, there is a certificate that was presented to me that says the proceedings are going to be governed by Schedule 6. Was there any opposition from applicant number 3? No. Section 50, subsection 6, paragraph C, it says, if a certificate has been granted, which it has been granted, then there is nothing that we can do. I therefore, you should employ you to disregard this particular argument because it is not relevant in as far as the issues are before you. Lastly, Your Worship, I'm not going to deal with the issue of accessory after the fact. Perhaps you would want to ask the state as to why. We do not want to engage in a trial before the actual trial. The bail law says if there is a prima facie case based on the balance of probability, we are not going to argue doctrines at this particular stage, because doctrines at this particular stage, Your Worship, they are not important as long as there is a prima facie case based on the balance of probability. Before you are charging the applicant number 3 with those counts. And the trial court is going to, of course, be engaging in the decision as to whether applicant number 3 is guilty or not. We'll then go to applicant number 2. But rather, before Your Worship, I go to number 2, the last issue on applicant number 3. Applicant number 3 went to the scene, misled the community, or members of the community who were there, particularly the family members. He said to them, no, look, I am unable to assist you because I am not on duty. But he goes to Baragwana Hospital, takes the 2 bullets, went to the scene, planted them there. But Your Worship, he failed to do what was morally and lawfully important of him to do. He did not assist the family. Why? Subjectively speaking.
Just a minute. You said, where did he get the bullets from?
According to applicant number 2, applicant number 3 got the bullets from applicant number 1. That is according to applicant number 2. I go then, Your Worship, to applicant number 2. Your Worship, my learned friend for applicant number 2 is taking us through the types of intentions. But for the sake of bail applications, that is not relevant. As to, is it dolus eventualis, indirectus or directus, for now it is irrelevant. Because we will be engaging in the process of the trial court. To make matters worse, my learned friend is also quoting from the 4th edition of Sneeman. But unfortunately, we are now on the 8th edition. And he is also talking about the common purpose. Your Worship, it is a doctrine. We cannot engage ourselves in doctrine unless perhaps this court would say to the state, let us start with the trial today. Then Your Worship, the state will start the trial today and engaging itself on those doctrines, engaging itself on the types of intentions that we have. My learned friend is also saying that the state has failed to submit statements and or confessions to the court. Your Worship, I don't know under which authority is my learned friend addressing you on when he says we are duty bound to give you the confession, or we are duty bound to give you the statements, or we are duty bound to even read the statement. In terms of Section 60, which governs bail applications, there is nothing, absolutely nothing. And Your Worship, I employ my dead friend that if he has an authority, a case law, he must give it to you. If maybe he has a section, he must then give it to you to say, this section is saying the state must give you confession, must give you statements, or must read the statements. Your Worship is also mentioning State v. Jonas Skitekat. He is mentioning there's two authorities. In the same line where he says the state did not read any single state witness statements. Your Worship, State v. Jonas, with due respect, it does not say that state must read statements to the court. No, it does not say so. If Your Worship, there is a particular paragraph, he must then mention it to you. Skitekat, it does also not say so. I have studied these two authorities, they say nothing about it. The other thing, Your Worship, yesterday my late friend was talking about hearsay evidence. Now, he wants us to read all the statements that we have in our position. But he himself yesterday said hearsay evidence is admissible in bail application. He is correct. That is why we don't need, as a state, to read statements. How many statements do we have? We have more than 5 statements. That is why the investigating officer in law, in terms of the bail laws, he can come and say, we have the following evidence. There's no need for us to call that particular person who will be giving that particular evidence. The reason is simple. Yes, the evidence is admissible in bail applications. Your Worship, I am failing to comprehend as to why my late friend was also inviting you to have a look at the case of Murukhangwe and others, and he told you about that case was here, and that was the decision, and another case was here, that was the decision. Your Worship, the law, in terms of the South African law, you are not bound by those decisions. Those two decisions, you are not bound, because the hierarchy, in as far as the South African law is concerned, it says that you are not bound. In fact, I implore you to disregard those two decisions, because you are not bound by them. Your Worship, he has also mentioned that the state is not honest when it deals with the life of applicants number 2. But Your Worship, it is the very same applicant number 2 who said, I am scared of applicant number 1 because applicant number 1 is threatening to kill me. That is why my dear friend yesterday was unable to address as to then your client's life is at risk, and you are saying it is applicant number 1 who's threatening your client, what do you want me then to do? Because, Your Worship, it is evidence before you that applicant number 1 has been threatening applicant number 2 to kill him. And, Your Worship, we also do have that evidence that applicant number 1 has been threatening applicant number 2. Your Worship, lastly on applicant number 2, the reason why applicant number 2 is detained where she is detained now is basically because we were advised by the court, not this one of course, to detain applicant number 2 to a place where we deemed fit to detain him. Then we come to applicant number 1. Your Worship, applicant number 1 is talking about the mens rea, but with due respect, at this particular stage, the issue of mens rea is neither here nor there. Why? It's because in front of you, you have a charge sheet that is indicating as to what are our allegations, what are our affirmations. There is also a statement from the investigating officer that is containing affirmations and allegations as to was there a mens rea is an issue to be decided at the trial court. The issue of motivation to kill, Your Worship, to murder the deceased, will also an issue that will be canvassed in the trial court. My late friend for applicant number 1 also raised an issue of the right to liberty. The right to liberty, indeed, Your Worship, it is contained in our Constitution. But also the right to life is also contained in our Constitution. What you have in front of you is evidence that applicant number 1 and 2 took the life of this young boy. Now the question is, what about the right to life? In fact, I want to argue before you, Your Worship, that in terms of Section 36 of the Constitution, which is our limitation clause, it says that all freedoms and rights are limited under this particular section. And State v. Dlamini says to you today, you can limit the liberty of all these accused persons. There will be nothing wrong in law to limit their liberty. Your Worship, indeed, I'm not going to, for the sake of time, I'm not going to quote the sections and whatever. But I want to take this court through some issues so that when the court comes to a decision, it is fair and just. Let's consider Section 60, subsection 4A, read with 65A to H. It deals with violence and whatever. In front of you, Your Worship, you have an evidence that the boy was shot as per the instruction to applicant number 2 by applicant number 1. And this young boy, it is evidence not rebutted that he was mentally not well. He had a Down syndrome. how do you then, Your Worship, begin to understand police officers who are in a police vehicle? Here is this young boy coming from this vehicle, rather coming either behind this truck, seeing the police van there, because we are told that this boy was very much fond of police or police cars. So he goes there, he is waving to the police. Applicant number one takes the microphone, swears at this boy, chases him away, the boy goes away, the boy comes back. The boy does not make any threats, does not pose any danger. Applicant number one instructs applicant number two to shoot this young boy. Your Worship, it is clear that they had the hunger to kill. I'm going to refer the court, Your Worship, to State versus C, 1998, Volume 2, SACR 72. It's a Cape Division. And Your Worship, I'm going to quote. However, the subsection sends a clear message to judicial officers that a bail risk may more readily be found to exist where the crime is a particularly violent one against another person. Close quote. Now, Your Worship, in front of you, you do have such case. So therefore, in terms of this authority, you cannot grant bail. Your Worship, what then happened is that applicant number one is threatening to kill applicant number two. How will you then release applicant number one, who is already in front of you through the addresses by a defense attorney for applicant number two, who says, should I be released, even if he does not say so, but that is my duty. He says, should I be released, there is a possibility that I might kill applicant number two, because already I have threatened her. I have indicated to her that if she does not cooperate with me, if she goes out and tell the truth, I will kill her. Will you really, Your Worship, risk that? Will you really today risk releasing applicant number one? To make matters worse, applicant number one is having previous convictions, 3 of them, of which 2 involves violence as an element. So already he has the propensity of not only committing Schedule 1 offense, but committing a Schedule 1 offense where violence is an element. Your Worship, the prevalence of this offense. In front of you, these are the applicants who are members of the South African Police. The allegations are that they have shot this young man dead. And the question is this kind of offense prevalent in our jurisdiction or in the entire country or not? That is the question that you are called upon to answer in terms of the papers. I want to implore you, Your Worship, to invite you. There is a document that was compiled that deals with people who have been killed in the hands of the police. And I've prepared that information, and I want your indulgence to put that on record because it's part of our argument. This document, Your Worship, it is titled does the delivery of justice in South Africa have to come dressed in a navy blue bulletproof vest, shotgun, and armed nyalas? Or can we imagine justice beyond that? That is the title of the document. This document, it says alone, only in 2019, 3,835 assault cases by the police were reported. It says furthermore that in 2019 alone, 397 deaths were reported caused by police actions. And 214 people died in police custody. Now, you should also, the IPID annual statistics from 2018 and 2019 confirms this. Because alone in Gauteng, there are plus or minus 150 cases that were reported between the period of 2018 and 2019. It tells you that, worship, there is this type of an offense is very prevalent. I go, worship, then to the next aspect. The emotional ties and whatever. Evidence is before you that all applicants, they don't own immovable property in Gauteng. They are renting. They are owning immovable, rather than movable. They don't own immovable, but they own movable property. Now, they've also indicated to you that they are taking care of their independence. But State versus Hlongwa, 1979, Volume 4, SA 218, bracket D. It was held there that the fact that an applicant support an independent is of little consequence when coming to granting of bail. I then should argue that if before you have that authority, then you cannot grant bail. The strength of the state case. I've heard my learned friends, Your Worship, addressing you on the strength of the state case. State versus Matibula.
So those are live proceedings in that bail application by the 3 police officers charged with the killing of Nathaniel Julies in El Dorado Park. You're hearing there from the prosecution responding to some of the arguments that were made by their legal representatives as to why they should be granted bail. A lot has been made out of the allegation. It's an allegation at this stage, of course, that there's a threat to kill the applicant number 2, accused number 2. That's Kaylin Whiteboy. We've heard this quite a bit in the last while, that there's a threat allegedly by Simon Scorpion Ndialvane, who is the accused number 1. It is alleged in those proceedings that he has threatened to kill Kaylin Whiteboy, Kaylin Whiteboy being the officer that fired the fatal shot that killed Nathaniel Julies. So the state, they're basically making a lot out of that and saying that, will the magistrate really risk releasing accused number 1, applicant number 1, Simon Scorpion Ndialvane, on bail when there's already a threat that he could commit a crime of this nature on the allegation made by Kaylin Whiteboy? And extraordinarily as well, something else coming out of there, the statement by the prosecutor that as it stands now, Simon Scorpion Ndialvane actually has 2 convictions on Schedule 1 offences, some of which involve an element of violence. This is a police officer. This is a person who is a commanding officer within the structures of the SAPS. I do hope that we're not the only ones who are watching this, that the policymakers and the commanders further up the structures of SAPS, also within the ministries and the portfolio committees in cabinet, civil society, are also watching all these themes that are coming out of this issue in as far as policing is concerned and in as far as the safety of South Africans is concerned. So we're going to leave it there for now, but coverage of this continues, of course, and our VUM dealer will report on it extensively. At the top of the hour, Jeremy Maggs is coming through to take you through the next hour with your lunchtime update. And that will do it from me for all angles for today and for the rest of the week. Of course, tomorrow is Heritage Day. Let me take just a break and see, and we'll talk again next week on Monday. With that said, take care.